As of December 2025, Lucy Letby is serving 15 whole life orders and will never be released. The question is no longer if she'll leave prison. It's how the pattern was finally proven. 3 clues pulled the picture into focus: abnormal insulin results in 2 infants, a roster map that kept circling the same name, and an eyewitness account in the Baby K retrial. This is how those clues surfaced, how they held up in court, and why the system around her is still being examined. Families of twins and triplets describe losses just days apart, pain that sits behind every page of this timeline. It didn't begin with headlines. It began with shift rosters and sudden code calls. Across 2015 and 2016, consultants on the neonatal unit noticed an unusual cluster of collapses and deaths. When those incidents were laid against staffing, a pattern emerged. Multiple events coincided with Letby being on shift, sometimes as the named nurse, sometimes simply present. Doctors raised concerns in meetings and asked for a thematic review. According to inquiry testimony and subsequent reporting, a senior nurse said she pleaded for the police to be called. The hospital did not do so then. By late June 2016, Letby was moved off the ward into non-clinical duties. The consultants still pushed for external investigation. The trust opted for internal and external reviews first. In May 2017, the call was finally made. Cheshire detectives launched Operation Hummingbird and began a cold, mechanical rebuild: who was on shift, what happened, and when the data stopped looking like chance. Investigators layered medical records, staffing rotas, and independent clinical reviews to test competing explanations: natural disease, infection, system failure, or inflicted harm. One result stood out early: lab numbers in 2 infants consistent with manufactured insulin, not the body's own production. Detectives didn't chase motive. They followed overlap, timing, and physiology. They gathered contemporaneous notes, messages, and handovers, then reconstructed minute-by-minute sequences around collapses. The first arrest came in 2018, with further arrests in 2019 and 2020. Charges followed. Here's the open loop we'll close in court. Do the 3 clues, insulin, rota overlap, and later an eyewitness, survive cross-examination? When the trial opened in October 2022 at Manchester Crown Court, prosecutors set out a case built on those strands: presence and timing, critical events repeatedly aligning with Letby's shifts beyond what statisticians or clinicians would expect by chance alone. Clinical anomalies, insulin results that experts said indicated an external source, sudden deteriorations that, according to prosecution experts, did not fit known conditions. Pattern evidence, notes, handovers, messages, and post-incident conduct. The defense challenged the medical mechanisms and argued that system failures, rare complications, and confirmation bias had not been excluded. They stressed that correlation is not causation. The judge directed jurors back to evidence, not speculation. This is where the 3 clues converged. First, insulin. Jurors saw laboratory findings and heard expert testimony explaining why the numbers pointed away from endogenous insulin. Alone, that wouldn't convict, but it was a friction point that resisted innocent explanations. Second, the rota map. Prosecutors walked through a series of collapses, placing Letby on or near each event, sometimes as the named nurse, sometimes not, but persistently present. The defense argued that a busy unit and overlapping shifts can produce coincidences. The Crown argued that coincidence had been stretched past breaking. Third, pattern evidence and behavior around incidents. Notes and messages that, in the prosecution's narrative, fit a timeline of presence, crisis, and aftermath. In August 2023, after months of evidence and direction on the law, the jury reached verdicts. Letby was found guilty of murdering 7 babies and attempting to murder 6 others. Some counts were not proven, and some returned not guilty. The judge described a cruel, calculated campaign against the most vulnerable patients on the ward. Families spoke about grief that arrived twice. For many, losses of twins or triplets within days. Letby denied all wrongdoing and did not attend sentencing. On August 21, 2023, The court imposed life imprisonment with whole life orders, the most severe sentence in England and Wales, meaning no possibility of parole. The sentencing sparked a separate national debate about compelling attendance for offenders who refused to appear, but the legal position in her case was clear. She would never be released. Yet one unresolved count from the first trial remained, the attempted murder of baby K, and it returned to court. At the 2024 retrial, prosecutors presented the third clue in its sharpest form, an eyewitness. A consultant testified about seeing baby K's breathing tube displaced and described Letby not intervening. The Crown argued intent from timing and conduct in the context of the wider pattern already established. The defense disputed interpretation and intent, warning against reading a sequence through the lens of prior allegations. On July 2, 2024, the jury convicted Letby of attempting to murder baby K. On July 5th, the court imposed an additional whole life order, bringing the total to 15, running concurrently. The retrial didn't widen the timeline. It closed a gap in the verdict sheet and reinforced the sentencing framework already in place. Appeals moved on a parallel track. On July 2, 2024, the Court of Appeal refused Letby permission to appeal the 2023 convictions, addressing grounds focused on expert evidence and trial management. In October 2024, a separate application connected to the retrial, raising issues including publicity, was also refused. Appellate courts were not rerunning the trial. They were testing whether the convictions were safe in law. The outcome left the jury's findings and the sentences intact. Beyond an individual's guilt, the system faced a harder mirror. In October 2023, police opened a corporate manslaughter investigation into the hospital trust, probing whether organizational actions or inaction amounted to a gross breach of duty. In March 2025, detectives widened their inquiry to consider potential gross negligence manslaughter by individuals. In early July 2025, 3 former senior managers were arrested on suspicion of gross negligence manslaughter and later released on bail while inquiries continued. Police emphasized that these developments do not affect Letby's convictions. For the public, the significance is straightforward. The criminal law is now asking whether leadership decisions themselves crossed a threshold when clinicians were raising alarms. A statutory public inquiry has been the other lens. Chaired by Lady Justice Thirlwall, it held public hearings from September 2024 through January 2025 and heard closing submissions in March. Over months of testimony, the inquiry heard from clinicians who described the strain of escalating concerns, from managers who spoke about decision-making under uncertainty, and from experts who mapped governance against events on the ward. The inquiry's job is not to retry Letby. It is to establish how concerns were raised, how they were handled, what failed, and what must change. By mid-2025, the chair outlined a path to publication in early 2026, after legal processes around warning letters and final drafting. That timetable matters because it signals that institutional accountability is still unfolding even though the criminal case is closed. So what precisely moved this from suspicion to proof? Start with the insulin numbers. In a hospital setting, lab anomalies demand explanations. When results point to an external source of insulin in an infant who shouldn't have it, policing questions change from, could this be rare, to, how did this happen? Then layer timing. If a cluster of events maps onto the same presence repeatedly, shift after shift, crisis after crisis, statistical arguments begin to strain. Finally, include conduct. What an eyewitness says they saw in the baby K case, and what records say about who was where, doing what, when seconds mattered. On their own, none of these closes a case. Together, subjected to cross-examination and judicial direction, they convinced a jury. There's a reason the story still pulls attention. It is not because of lurid detail. Those are neither needed nor appropriate. It's because the stakes are absolute, the setting is supposed to be safest, and the signal, the pattern, was faint until it wasn't. Inside, you have clinicians comparing notes, noticing repeats, and pushing, administrators weighing uncertainty, reputational risk, and due process, and police reconstructing a timeline where medicine and law have to meet. Outside, you have families who live with the outcomes, anonymized in the record but present in every line. For viewers trying to make sense of the aftermath, Two tracks run in parallel. Track 1 is sealed. Letby's convictions and sentences stand. The retrial added a conviction and another whole life order. Appeals have failed. Track 2 is open. Corporate and individual liability for leadership decisions are being examined by police, and the Thirlwall inquiry is preparing recommendations about systems, escalation, and neonatal safety. Those processes won't touch the jury's findings about Letby. They address the question behind almost every comment thread. What should happen inside a hospital the moment a pattern like this is suspected? The story's through line is a sequence of turning points, not a single reveal. First, consultants noticed an unusual pattern and insisted it be treated as such. Second, the trust removed Letby from the unit, but delayed calling police. Third, once detectives entered, the frame shifted from, "Is this chance?" to, "What does the evidence say when you align timing, physiology, and presence?" Fourth, a jury weighed that evidence against a defense that urged caution about medical uncertainty and systemic error, and convicted on most counts. Fifth, the system widened its view to ask whether leadership decisions met criminal thresholds and how governance should change. As of now, legally, nothing has moved the convictions or the sentencing framework. Lucy Letby remains on whole life orders, including the additional order imposed after the 2024 retrial. Institutionally, the inquiry's report is expected in early 2026, and police investigations into corporate and gross negligence manslaughter continue on a separate track. Emotionally, the family's grief doesn't end with any of that. Neither do the memories of clinicians who warned, waited, and kept pushing. If alarms were raised and the proof emerged in stages, which force finally moved the system? The insulin numbers, the rota map, or the willingness of doctors to keep pushing when it was easier not to? And when leadership decisions are weighed by criminal law, should that change how hospitals respond to red flags tomorrow?